Right out of the gate, the defense leans into a strategy that looks reasonable on the surface, but is actually calculated positioning. Framing expenses like furnishing a second home and maintaining professional appearance isn't just explanation, it's narrative control.
So the target bill was spent, outfitting a private space for the kids in his apartment because Miss Dreyer continues to reside in a marital home and he has an apartment. So he had to outfit it with some items for the children, right? And then, Mr. Dreyer has a job where he has to maintain professional appearances, so he had to buy some new clothes. So if we're going to nitpick each and individual, spending habits, again, I'll just remind the court that she's the plaintiff and we need to move this case forward. So we can't be picking apart each other's, spending habits, but rather we can separate financials and move on with the finalization of this. So we'd ask the court to take all that into consideration, give us a temporary order we can move forward with and get us ready for trial.
What's our trial date?
I'm going to say, I don't remember off the top of my head.
I don't either. That's why I'm asking.
Sorry, I should have looked that up. Let's see.
I believe
We
it's
did
May
have it.
27th or 28th.
Okay, thank you. So coming up shortly.
Yeah, really, really quickly. 5:28, 2:00.
All right. All right.
Judge, not to interrupt, but May 28th at 2:00 is a settlement conference.
Oh, I'm sorry. You're right. It does say settlement
Yeah,
conference.
I didn't think we were scheduled for trial.
We had asked for it to be set for trial. That's why I said that. And I knew some dates had gone on. But yeah, we had asked I asked for it when I appeared at the motion to excuse Amy. I'm sorry,
Okay.
Rademacher.
Okay.
Ms.
All right.
Rademacher. And so, yeah.
All right. Well, while we're on that subject, have everybody here. Ms. Van Miller, could you look and see what we could set for a trial date?
Yeah, so the filing date on this is August 8th. So are we looking in July?
I would think so. If not June.
If not June.
Yeah, June, I would think. Give us a little more breathing room time-wise.
And are we looking in person or via Zoom?
Either is fine with me. I don't think there's anything particular to this case that would require an in-person appearance. So I'm fine with that if Emily is.
Ms. Schultz?
I agree with that.
Okay, then why don't we Zoom?
Okay, then we could do June 29th, Monday from 9 to noon.
That is open for me. I have a review hearing, but I can probably get it covered.
That works. That's fine with me as well.
Okay, we have a trial date. All right, Ms. Wolfram, did you have anything else you wanted to say? We kind of went off on a tangent there.
No, no worries. I think I'm all set. I just think, like I said, especially now that we do have a timeline, I do appreciate that, but the parties are operating without any temporary orders. And every time that we think, and I do think that it's possible to come to an agreement, but basically what happens is when we go sort of off the record, I'm just going to be honest with the court, Ms. Dreyer kind of pulls back and then we don't get one and here we are again. So as much as I'd like to say that I think we can, and we can certainly come up with maybe some minute details between us. And I have every confidence that Ms. Schultz will be able to achieve those things for us. But Ms. Dreyer seems unwilling to fully commit to every agreement that we come to. So we really need that direction from the court so we can lock it in because it creates a chaotic situation when we depart.
And in your response, you asked for this to be referred to the front of the court. I'm not sure that's going to happen.
No, at the time, Your Honor, Ms. Schultz had not been. When I filed it, she had not retained additional counsel. I don't think that we need a friend of the court. I think that us attorneys can work that out. And frankly, the parenting time and custody is, for the most part, pretty much in agreement. I think, again, there's some parameters that we could discuss, but with regards to the actual schedule, I think there's no need to change that. So I would withdraw that so long as Ms. Schultz remains on the case.
Right, Ms. Schultz?
Thank you. I would agree with that as far as friend of the court goes. I mean, if we're set for trial that quickly, then I don't see a need for that at that time. We can negotiate parameters. The concern here, and I mean, again, I recently entered this case, so I don't know, what has happened before, during, after mediation, as far as the minute details of trying to get an agreement. But the reality here is that Ms. Dreyer has stayed home with the kids for a significant amount of time. She's been out of the workforce. Mr. Dreyer's, earned all of the financial support for the household. And since they've separated, he's expecting her to live on $2,000 a month. And it's not realistic. So while she's attempting to secure employment and alternate income sources. At this point, she's not yet done so. She absolutely needs a contribution to attorney fees. Mr. Dreyer's got almost $36,000 sitting in an account. So it's a little disingenuous for him to then state that he doesn't have the money. It's sitting right there. So she is requesting child support, spousal support, at least to get her through. And for the time being, we're set for trial here pretty soon. So Mr. Dreyer is not going to be, we can reassess this at that point based on where Ms. Dreyer is at the time. And then in the response, it's really important that Ms. Dreyer hasn't decided yet what she wants to do, what she's able to do. What she's trying to do is breathe financially, and before she can make some decisions on what she would like to see happen with the house long term. So those are really the only things that I would add at this point.
I'd like to briefly respond, Your Honor. There's not that 36,000 includes that 16,000 that they're complaining about, right? So that's the problem, is that that's double dipping. So do you want that money spent, or do you want to account for it, right? Like, that's the question. There was two things. I'm sorry. Let's see. Oh, and the $2,000 a month is in addition to 100% of her expenses being paid. So my client is still maintaining all the household expenses. So yes, the $2,000, it's like $2,400 of child support, but it's in addition to her living expenses, her utilities. He's paying all the bills and paying child support. So, when we're talking about even more money, we're not asking her to survive on $2,000 a month. She's having $2,000 to support her portion, support the children on her parenting time, but the rest of her household expenses is 100% being paid. So that those are just two clarifications.
All right. Well, it sounds to me like there is a stipulation between the parties that just continue the status quo for the time being regarding custody and parenting time. I'll grant that portion of the relief requested. And nobody addressed the third, although I read it, the prohibition on third parties.
I would request that the court does put that in place. I mean, certainly without revealing too much, that was, a point of contention for the mediation. So it was like potentially agreed, but then not. And it was some time ago. But with the idea that my client is maintaining the marital home, he is struggling with the fact that we're moving a person in while also not deciding whether we should sell the house or not, right? This is becoming really uncomfortable for my client to have to support her lifestyle and her,
Well, without commenting on whether that may be true or not, any of that, I will indicate that the court does routinely, for the best interest of the children, during the pendency of a divorce, prohibit third parties from being introduced to the children. Either party.
Indeed.
Because they need the stability during that pendency, at least. So I will grant that as well. I'm going to deny the request that the plaintiff or that the defendant be given exclusive use of the marital home and that plaintiff vacate at this time. I do think that we have a trial date set and we can deal with it at that point. I will grant leave for defendant to file his counterclaim. And I think I'm just looking at your prayer for relief. Ms. Wolfram, does that deal with all of it?
Yeah, I think so, because we agreed to the mutual restraining order, so that was stipulated.
Okay.
And I think that was in their response.
And other than that, I'm going to leave everything else, the financial orders, the same.
Notice how quickly the judge moves. No hesitation, no overanalysis. That decisiveness sets the tone moving forward. Unresolved issues will be managed, not debated endlessly. The final rulings reveal a careful balance between restraint and control. Denying exclusive use of the marital home avoids giving either side a strategic advantage before trial. That's intentional neutrality. At the same time, Allowing the counterclaim keeps the case evolving, ensuring both sides can fully present their positions. The judge is effectively saying, not now, but soon. By leaving financial orders open, the court preserves flexibility while signaling that deeper decisions are coming at trial. This keeps pressure on both parties. Neither side gets full relief, but neither is shut down. It's a controlled pause before escalation, and it forces both sides to prepare for a more decisive confrontation ahead.